Welcome once again to Lehto's Law. Here's Steve Lehto.
Had a whole bunch of people send me a story out of California, and this is the goofy kind of thing that sometimes you hear from courts interpreting laws. And this might sound like a stretch, but it's not that far out of line. It might still be odd, but we'll get there. California court rules that bees are fish. The headline actually says, California court rules that bees are a type of fish in order to protect them under the state's Endangered Species Act. So there's a federal Endangered Species Act and there's a California state Endangered Species Act. And this story is from BusinessInsider.com. Mia Jankovic wrote it, and it was sent to me by a whole bunch of people. Judges ruled this week that bumblebees can be classed as fish under California environmental laws. That's because there's protection for fish, but not specifically for bumblebees. This unlocks protections for the state's 4 endangered bumblebee species. There are 4 different bumblebees in California that are endangered. I was unaware of that. The ruling clarifies the state's confusing classification in its environmental protections. And if you think it clarifies things to say that bees are fish, sure, why not? 3 judges in California said Tuesday that bees can be legally classified as a type of fish in their ruling that brings added conservation protections for the endangered species of bumblebees. The issue presented here is whether the bumblebee, which is a terrestrial invertebrate, falls within the definition of fish. And they concluded it does. So what we're talking about here is not how biologists would describe this or ichthyologists. What we're talking about here is how it's described in the law, lawmakers. Formerly, the problem for bee lovers and lovers of all Californian terrestrial invertebrates was down to the way protected animals had been classified under state law. Although 4 different bee species were classified as endangered in 2018, land invertebrates are not explicitly protected under the state's Endangered Species Act. That law protects endangered native species or subspecies of a bird, a mammal, a fish, an amphibian, a reptile, or a plant. Now, if you look there at that list and you're using like what you learned in 7th grade biology, you go, well, I wouldn't think a bumblebee is a bird, although it does fly. Don't think it's a mammal. I wouldn't think it's a fish, but I could be wrong. I wouldn't guess amphibian, reptile, or plant either. But here's the thing. The CESA's, that's the law, Fish and Game Code, which establishes the basis on which plants and animals are protected, defines fish differently than you or I might define fish. A fish includes the following: a wild fish, a mollusk, a crustacean, an invertebrate, an amphibian, or part, spawn, or ovum of any of those animals. So the question is, a mollusk. Nobody would have thought a mollusk was a fish either, but that was the classification. They had all these things to say these things are all fish under this statute. So given that many of the above marine creatures aren't even fish, California's been arguing ever since about whether invertebrates could apply to bees. The appeal overturns an earlier ruling that came back in 2020 that was backed by major agricultural groups. There, the judge argued that invertebrates in the Fish and Game Code's fish definition only applied to marine invertebrates, like sea urchins. Now, here's an interesting thing. Where do you get that from? It doesn't say marine invertebrates. It says invertebrates. So it looks like both sides were playing a little bit with the rules and the definitions. On Tuesday's appeal, the judges argued they are obliged to liberally interpret CESA's terms in order to make sure it can be effective. And that is, I've talked about before, the theory of statutory construction. There's actually a whole bunch of rules that apply to how you construe a statute. When you're reading a statute and you ask yourself, how should we apply this? How do we interpret this? And if there's a statute that's considered remedial in nature, it's designed to remedy something, which makes it remedial. It's designed to fix a problem or solve an issue. They tend to construe those liberally, meaning that they think, well, the legislature or the assembly was passing a law to fix a problem, so we will construe this broadly if that helps fix what the perceived problem was. So they're going to liberally interpret California's Endangered Species Act terms in order to make sure it can be effective. Here's the quote. Although the term fish is colloquially and commonly understood to refer to aquatic species, the judges said, legislative jargon in this case could be justified in expanding the definition of fish beyond what you and I would typically presume to be fish. The judges noted that frogs are also protected under the fish section, and that, of course, is because they're included in amphibians. They also argued that land-based invertebrates have been protected under the category of fish under the statute in the past, such as in 1980 when a snail was protected. So there was apparently a thing called a Trinity bristle snail was protected back in 1980, and it was considered a fish as well. The judges described how California's legislature has wavered for years over whether or not to explicitly include invertebrates in the act, presumably saving them the trouble of having to expand the definition of fish. In one instance in 1985, the judges said that lawmakers reasoned it was unnecessary because invertebrates were already included in the definition of fish. Adding the term invertebrates in the legislation would only serve to confuse the matter. They cited lawmakers who'd said that. The woman who's the California program director at Defenders of Wildlife, which is one of the groups that brought this appeal, said it's a great day for California's bumblebees in a press statement following the ruling. And of course, many people are going to joke and say, yeah, the bumblebees woke up one morning and discovered they were fish. So this, however, I'm not sure I agree with this, because I wonder if that was the intent of the legislature or the assembly. And in California, they call their legislature the assembly. And technically speaking, that is the official term of it. But it is a legislature. So invariably, I get one or two people who say, Steve, it's the assembly. I know that. But it is also a legislature because it's a body that legislates. However, when you look at a statute like this, and just as a thought exercise, think of these things and consider these things and ask yourself, what did the legislature intend? So in other words, when they were passing this legislation, if you had asked them, do you think this protects bumblebees? The question is, would they have said yes? And if so, you'd say, where? And if they said, well, if you look at the broad definition of fish, and it actually includes all of these other things, including invertebrates and crustaceans and mollusks and amphibians, obviously those terms are being used differently here than they'd be used in, like, say, a biology textbook in high school. And that very well could be. And the court seems to indicate that that's what they think some of the assembly people would have said if they had been asked. But the other question, of course, people are going to ask is, then why don't they just go in and amend the statute? Well, there's a reason you don't want to do that. A lot of times if you go in and amend a statute, the moment you've got that thing on the operating table, everybody wants to crowd around and modify it their own way. A lot of times they're very skeptical about bringing out a law and saying, hey, let's rework this to solve these kinds of problems. But I can give you the best example, and this popped into my head. When I saw the headline, I knew exactly what it was getting at, and I also knew exactly the example I'd give you. Because Michigan's lemon law, which is the law I work with the most, talks about if you buy a brand new car or truck and it's got a problem that can't be fixed in a certain amount of time, you get the manufacturer to either replace it or repair it, right? Okay. So you heard me say new car or truck. New. What's the definition of new under Michigan's lemon law? Well, if you look it up, it says a new car is any car that still has a manufacturer's express warranty intact on it, which of course includes used cars. So technically speaking, the new car definition includes used cars. Some of them, late model used cars, are new. And most people understand the distinction that I make when I say you buy the car brand new and you're the first titled owner. The second you sell it, it's used. It can only be new that one time. But according to Michigan's lemon law, it could still be new for the second owner if the warranty was still intact from the manufacturer. And then you say, well, Stephen, why do you say that about the new car? And that's because other definitions say that you have to bring your claim within a certain amount of time of its delivery to its first owner. And 99.999% of the time, that does involve a new car in the way that you and I understand it. But technically speaking, the statute says new cars can be used. That is, used cars can be considered new, just based on the wacky definitions there under the lemon law. And it doesn't hurt anybody. It causes a little bit of confusion sometimes. So I've had people tell me, they say, Steve, I've read the statute. It says that a car I bought 2 years down the road with a 336 on it is still considered new. And I say, yeah, technically speaking, it is. But if you bought it 2 years down the road from when it was delivered to its original owner, and it has its first problem during your ownership, it won't qualify as lemon, because under the lemon law, the first repair has got to occur within the first year of ownership of the first owner, back here, not here. So, like I said, statutes often read funny, and sometimes you got to really dig into them, see what they say, and then go look to see how the courts interpret them. And yeah, this is an unusual outcome, because most people would never guess that bees are fish. But I also told you a while back about the case where the court said that spiders are insects under the insurance code. So nothing surprises me anymore. But the story's from Business Insider. Mia Jankovic wrote it. California court rules that bees are a type of fish in order to protect them under the state's Endangered Species Act. Sent to me by Alexander, Tim, Carlos, Nate, Dan, Joe, Mark, Phillip, my good friend, Arthur, and Rick. Thanks a lot. Questions or comments, put them below. Otherwise, I'll talk to you later. And quick note, I'm wearing an Ohio State Buckeyes shirt. I am a Michigan fan, and I've had people tell me, Steve, would you ever wear an Ohio State Buckeyes shirt? Yes, I would. And I do, and I am. There's just 1 week out of the year I can't wear it. That's when Ohio State plays U of M. But I'm a big supporter of educational facilities, universities, schools, and otherwise, and it's a fine institution. It's just that their football team deserves to lose at least once a year. And sometimes it even happens, like last year. So there you go. Talk to you later. Bye-bye.
Thank you for watching Lehto's Law. The secret of happiness, you see, is not found in seeking more, but in developing the capacity to enjoy less.